Good afternoon, everyone, and welcome to this month's Employee Benefits Compliance webinar. As we are kicking off here, as we usually do, I would like to start by asking you, our audience, a couple of polling questions. Did you know that June is Men's Mental Health Awareness Month? Well, it is, and this month we would like to ask you a couple of questions on that topic. So you should see two questions pop up on your screen as we are kicking off here. If you would take a moment and answer those questions for us. And while you do so, I will cover a few other items. So again, I'd like to welcome you to today's compliance webinar. I am Jenny Bedeau with Assurex Global. Today we will be hearing from Loomlight on non-discrimination rules. And we would like to extend a special thank you to your local benefits advisors and consultants who are partners of Assurex Global for making today's webinar possible. We do welcome your questions during the presentation today. We do often get a lot of questions on this topic, so please submit your questions over to us using that Q&A function towards the bottom of your screen. We will address as many of those questions as we can. We are recording our webinar today. The recording and the presentation slides will be available early next week from that benefits advisor who invited you here today. And I will also drop a link to the presentation slides into our chat section here in just a couple of moments. And if you are just joining us, you will see two polling questions on your screen. Again, June is Men's Mental Health Awareness Month. Our polls this month are focused on that topic. And in addition to the two questions that we're asking here at the top of the hour, I will have two related questions during my closing comments, so please do stick around for those as well. We do appreciate your responses to our polling questions. Your responses help inform our monthly market check surveys, which are a deliverable we put out based on the responses to these polls, and they provide valuable insights into how you and your fellow employers are thinking about and approaching various topics. So I will close out this poll here in just a moment, and I will share responses out so you can see how your peers on the call are approaching men's mental health. So give me just a moment on that. Okay, so for that first question, just over half of you are saying not specifically considered. Some of you are maybe kind of discussing it or considering it. And on that second question, probably unsurprisingly, EAPs are the most common thing, but actually a good number of you are offering mental health counseling or therapy benefits. So again, thank you for your responses to those questions. We really appreciate that. But now let's get into today's content. So joining us today from Loomlight is Regan Debon. She is their Director of Compliance Consulting. Regan, thanks for joining us today, and I'm going to turn it over to you.
Thanks, Jenny, and thanks everyone for joining us here today. We're going to spend time talking about non-discrimination rules. And I know a lot of times employers, when they're thinking about this, they're not specifically asking about whether something is discriminatory necessarily. We get questions in all kinds of different flavors. And so I'm going to start off today kind of asking the types of questions that we often hear when we're working with employers. And then when we hear these types of questions, what we jump to are the non-discrimination rules and kind of where we have to apply those or how they might limit what the employer's trying to do. And so the way that questions come in is often, we want to do this for this employee or this for this group of employees. When is that okay? Or is that okay? What do we have to think about? So the first way I want to look at this is when we're doing it on an employee by employee basis. So one of the flavors that we see this question come in as is, can we differ waiting periods? Or can we differ benefit plan options? Can we differ the employer contributions? Can we offer opt-out incentives to some and not others? And specifically, can we just do it? We've got somebody that we're trying to recruit, or we've got somebody that's really important to us asking that we want to make sure that we keep. And so can we do something just for this employee A? When you ask us if you can do something different on an employee by employee basis, we're always going to tell you that that's not a great idea. One of the biggest concerns is probably that when you do something on an employee by employee basis, it's going to risk claims of discrimination against a protected class. Think of things like gender, age, health status, There are many more protected classes that we know that we can't discriminate against. And even if that's not your intention as the employer, when you're doing things on an employee by employee basis, you always have that risk that somebody's going to claim that employee A got it because, whatever reason. And then I didn't get it. I'm the same. We're similarly situated, but because of my health status, I didn't get the same thing. So even if that's not your intention, you're always risking that perception that individuals are going to see it that way if they find out that a particular employee is getting something different than another employee. So not a great idea. The other things that we think about, and I want to spend a few moments talking about this, whether it's on a kind of an employee by employee basis or maybe even a little bit broader, there are a bunch of different rules that come into play that make it, really much safer for employers if they want to do benefit differentiated to do it within a particular class or within a category of employees. And these are not an exhaustive list, but many of the different things that we think about and the reasons why that we would direct you that way to look at a particular class or category and offer benefits accordingly. So ERISA requires that we're really supposed to be offering benefits uniformly within bona fide classes of employees. So think about salaried and hourly, different locations, Minnesota and Texas, for example, or doing it differently, based on a specific job title that's in place for other purposes beyond benefits. That's going to make you much safer under ERISA rules. When we think about health status, the reason why we can't discriminate there is HIPAA rules that protect employees and their family members, that we're not supposed to base what we're offering or how much we're offering or the cost of what we're offering based on health status. And that's where we get our wellness program rules as well. For those of you that are smaller employers and offering fully insured plans in markets where it's age rated, you have to be careful not to discriminate against older employees. Think about when you have those age-rated plans, you kind of have two options there. You can either develop a composite rate and then charge everybody the same thing, and then you're clearly fine. If you stick with those age-rated premiums and then you're charging differently based on employees' age as they're enrolling in the coverage, what the rules say is that you have to do the same percentage. So you're paying the same percentage for your youngest employees as you are for your oldest employees, and then you'd still be okay under the ADEA rules. We know from an employment law perspective, as well as how we offer benefits, we can't discriminate based on a disability. So we have to be careful not to target particular conditions or disabilities in how we're offering benefits. Medicare secondary payer rules, we're seeing those come up more and more often as employees are staying in the workforce beyond age 65 and then being eligible for both Medicare and the employer's plan. For most employers, if they have 20 or more employees, they have to be careful because their plan would be the primary payer. And then the rules say that we can't discriminate against those individuals based on their Medicare eligibility, and we can't incent them to take Medicare over the employer's plan either. Title VII is kind of a broad employment law protection. It applies to a lot of different employment aspects and kind of how you're hiring and in how you're offering things within the job. But one of the things that would fall under protection for Title VII would be your employee benefit offerings. And so that's where the protection against discrimination based on race, color, religion, sex, and national origin that we're all familiar with at that federal level, that would apply for employee benefits as well. And then final one on my list is GINA, which is about genetic information. We have to be really careful that we're not collecting that information and then differentiating based on that either. And most employers, we don't really have to get into that. They're aware of that and not using that for those purposes. But just one more thing we have to be careful of. But these are all the types of different things that we would think about when you're asking about benefit differentiation, and that we become more and more worried about if you're doing things differently for a particular individual versus based on a class or category of employees. But let's assume that you really are trying to do it within a particular class or within a particular category, and that's certainly more common. That's what we run into most often, where you're looking at by location, we want to do this for salaried employees, we want to do this for hourly employees, we want to offer this for management, we want to offer something else for the rest of our rank and file employees. So same question that I started off with before, can we differ in a bunch of different things that you might want to differentiate in how you're offering those benefits, but we want to do it differently for different classes or categories of employees. Then can we do it? Well, then the answer is going to change. Then we're going to assume that you probably can. The answer is often yes, that should work. But then what we have to think about are the tax benefit non-discrimination rules. And that's what we're going to spend the bulk of our time talking about today, because most of the time we are offering benefits on a tax favored basis, which is great for employees and their taxation on their income, as well as for employers on payroll taxes. It's a win both ways. But what the IRS has said is if we're going to give you this big tax break on benefits, you have to follow these non-discrimination rules. And the rules, kind of the concept behind all of the different flavors of the tax benefit non-discrimination rules, is that they restrict the ability to favor highly compensated or key employees. So that's going to make some of the differentiation that employers want to do a little bit more difficult. So for example, if you're trying to do something more generous just for management or just for your executive team, and you want to do that on a tax favored basis, that's more likely to be an issue under the tax benefit non-discrimination rules. If you're differentiating between locations, going back to my example of Texas versus Minnesota and saying we want to offer these benefits in Minnesota, we want to offer this other kind of group of benefits or on different terms to the employees in Texas, that's more likely to be okay, because that's not necessarily that you're favoring your highly compensated unless they all tend to be at one location. So let's spend some time digging into those tax benefit non-discrimination rules, assuming that you're just trying to differentiate between classes or categories. What does that mean, or when is that more likely to be okay or not? How do you test for that? That's what I want to spend our time talking about today. I already alluded to that this is all tied to taxation. So if you choose to offer your medical, dental, vision benefits on a taxable basis and you're including the value of it in your employees' taxable income, they're paying for it all on an after-tax basis, we don't have to think about these rules at all. But most of you are not doing that. Most of you have a cafeteria or a Section 125 plan set up that employees are allowed to make pre-tax contributions toward their benefits. Maybe have account-based plans like health FSAs, dependent care FSAs, HSAs set up that they're making, again, pre-tax contributions toward those. And the employer's contribution is not being imputed as additional income either. They're getting all of that on a non-taxable basis. It's not being included in their income taxes. It's not subject to most payroll taxes for the employer either. But then we have to be careful about these non-discrimination rules. And it's the IRS that cares about this. So often we get asked about, who would care about this, who would audit and look for this and enforce it. And that would be the IRS, because it's all about taxation. If you ultimately are not in compliance with the non-discrimination rules for your plan, the risk is to the highly compensated and key employees who are participating in your plan. So it doesn't disqualify the entire plan. For example, it doesn't take away the tax break for everybody that's participating in your cafeteria plan. But for those highly compensated and key employees who participate, the IRS would have the ability to not only today, but retroactively, much like they can do with a lot of other things with their auditing, is they could go back and look and say, you didn't pass discrimination testing for the last 3 years, and therefore your highly compensated employees who are participating, we're going to take away that tax break. We're going to go back retroactively and include whatever benefits they ran through that plan in their taxable income. We're going to recharacterize it, and then the employer would also owe additional payroll taxes. So just kind of understanding the risk here. It's not a specific penalty for failure to comply with these rules. It's a reversal of the taxation for the highly compensated and key employees who are participating in a discriminatory plan. We have a bunch of different flavors of tax benefit non-discrimination rules that apply depending on what types of plans or structures you've got in place. And so this is the list of different ones that we run into most often. Section 125 would apply to any of your benefits that are run through your cafeteria plan. If you have any self-funded group health plans, your medical, dental, or vision, any of those could potentially be self-funded or self-insured, as well as the health FSA or an HRA. Those are also flavors of self-funded plans. They're subject to Section 105H. Your dependent care FSA, or it's formally referred to as a dependent care account plan, a DCAP, they're subject to Section 129 non-discrimination rules. Group life insurance is subject to Section 79 rules. Those Section 79 rules say if you comply and with our non-discrimination rules, we'll allow you to provide just the first $50,000 in benefit on a tax favored basis. Still, everything above $50,000 is taxable, but at least that first $50,000 you can provide on a tax favored basis under 79 rules. Educational assistance programs are subject to Section 127 rules, and then adoption assistance programs are subject to 137. We're going to talk about kind of the first three the most today because those come up more often. They all have a little bit different rules and definitions about how they define things like highly compensated or key employees, as well as the different testing that they run. But ultimately, at the end of the day, the idea behind all of these the same is if you read the IRS kind of statutes and regulations, they're all prohibiting you from offering any of these types of benefits in a way that overly favor the highly compensated or key employees. So a couple examples of how you would start to think about your benefit package and which rules you would be subject to. Most of you are going to be subject to multiple different rules and would have to run testing under multiple different rules to really get a snapshot of whether your plans are in compliance. So my first example here, if you have a fully insured medical, dental, vision, and life plan, as well as a health FSA, HSA, and a dependent care FSA or a DCAP that are all offered through a cafeteria plan. So you have a mix of fully insured premiums and then these other account-based plans, and you're running all of them through your cafeteria plan. All of the benefits together are going to be aggregated and subject to 125 rules for the cafeteria plan. And then individually, the life insurance would be subject to 79. The health FSA would be subject to 105H, and the DCAP would be subject to 129. So you'd test everything together under 125, and then the other three individually under their specific sections. My second example, we have a fully insured medical, dental, and vision offered through a cafeteria plan. So you have kind of a premium-only cafeteria plan or a POP plan. And then you have an HRA. Those aren't run through the cafeteria plan because they're funded just solely with employer dollars. So we'd have to look at the medical, dental, and vision plan together. They would be aggregated and subject to 125 testing because they're offered through a cafeteria plan. And then the HRA on its own would be subject to 105H. So just giving you a sense of, and if you're working with vendors and things to understand, which benefits you offer and they're asking which tests you want run, know that a lot of times you're going to have to run multiple different tests to ultimately look at potentially, one time everything together that's run through your cafeteria plan and then picking the individual benefits apart and applying the appropriate rules to those and testing them on their own. HSAs are a little bit different. We get lots of questions around this, and I know that there's a lot of strategies around differentiating, especially employer HSA contributions. And so the question is often, well, if we do a match, or if we do it, an HSA contribution as part of a wellness program, or if we do it, kind of depending on position, does that matter? And can we do that with the HSA? If it's not run through the employer's cafeteria plan, if employees aren't able to make pre-tax HSA contributions, then comparability rules apply that require uniform employer contributions by tier of coverage. So there really isn't any flexibility to differentiate. That's not the way most of you have your HSAs set up. Most of you have your HSA as part of your Section 125 cafeteria plan, and you're allowing employees to make pre-tax HSA contributions if they want to. And when that's the case, you have a lot more flexibility. You're allowed to differentiate for, the types of examples that I just gave before and do it differently for different employees. But then it will be included as part of your Section 125 testing. So the HSA would never be tested on its own, but in aggregate, it would be looked at with all of the rest of the benefits run through your cafeteria plan. The reality is, unless you're already pretty close to failing or having issues with passing the discrimination test, the HSA isn't going to necessarily impact the results one way or the other. But especially for small employers, and if you're already having some trouble meeting the discrimination rules, it's possible that if then you have your HSA set up through your cafeteria plan and your highly compensated employees are the ones putting the most money in there, that could potentially cause a problem under 125. As we think about all of this and we say, well, we can't favor the highly compensated or we can't favor the key employees, depending on which rules we're talking about, we have to understand who are those individuals when we're going through and looking at, who's potentially getting the better benefits or who we have to be careful with. Unfortunately, they don't use a consistent definition for highly compensated. It is the same under 125 and 129 for the most part. It's mostly, officers, not under 129, it's not officers, but at least under 125. And then it's greater than 5% shareholders or owners, but only if they're also employees. So that's not always going to be the case. You've got, for example, C Corp shareholders where they may owe a decent amount of shares in the company, but they're also W-2 employees. That's where this would come into play. But for a lot of you, if you've got partners in a partnership or greater than 2% shareholders, they are just in an S Corp is what I meant to finish that. They're owners and not employees. And so they don't fall under this category. So greater than 5% shareholders if they're also employees. But then where we get most of the individuals falling into this highly compensated category is based on compensation. It does get adjusted by the IRS each year. And we look back to the previous year, unless they're brand new employees, and we kind of look at their current year in a lot of cases. But most of the time, we're looking back at their annualized compensation for the previous year. So if they had 160,000 or more in compensation, and that's really, think of it as kind of everything that would show up in their box one wages, then they're considered a highly compensated individual in 2026. And then that gets bumped up at approximately 5,000 or so each year. So, looking at when we'll look at in 2026, approximately 165 to 170 to see who's a highly compensated individual for 2027. So that's for 125 and 129 rules. For 105H, we're still looking at officers. We're still looking at shareholders if they're also employees. The biggest difference in this definition, though, is that it's not tied to a compensation threshold at all. It's just the top 25% highest paid employees, whatever they might be paid. So that can really change who falls in the category of highly compensated. Before I give a couple examples of how these two can be different, I do just want to point out, especially for those of you who may have a lot of employees in your staffing that are at that 160 or higher, and so you have a lot of highly compensated individuals, it is an option to make what's called a top paid election for purposes of 125 and 129, and then you would only have to treat the top paid 20% as highly compensated. So I do just want to call that out. I don't know that a ton of employers take advantage of that, but if you really are heavy in the highly compensated population, just because of the type of industry that you're in, for example, or type of people that you're employing, you do have that option to make that top paid election and potentially have fewer individuals that qualify as highly compensated. So just an example of where this can come up and make it really different and where this might really impact employers is, for example, if you have everything fully insured and you're really only ever worried about kind of the 125 testing, and then you're moving some of your benefits to self-funded and you're assuming you'll still be fine. it can really be a different result depending on the makeup of your employees and their salaries. So I've got an example here of how those two can really be different. Let's assume you have 500 employees, all of them who earn $125,000 or less. That would mean that other than officers and then those shareholders who are also employees, you wouldn't have any highly compensated individuals under 125 or 129 because they're all below that 160,000. But under 105H rules, if you have a self-funded group health plan, it's going to be the top 25% highest paid, even though they all earn 125,000 or less, which would mean that 125 of those 500 employees would be highly compensated. In the second example, I flip it. Still have 500 employees, all of whom earn greater than 180,000. So now they're all above that $160,000 threshold. That would mean that all of the employees are highly compensated individuals under 125 and 129, unless the employer makes that top paid election, in which case, it would just be the top paid 20%, the 100 top paid. But under the 105H rules, it's still going to be the same. Now it's still that top 25%, so it's just the 125 employees that would be highly compensated. And so just important to understand if you're having testing done and maybe you're passing with flying colors under 125, but then you're failing 105H and vice versa, this could potentially be why, just based on that definition of highly compensated individuals under the two separate sets of rules. I did just get a question about partially self-funded or a level funded plan and where that would fall in all of this. If you have a partially self-funded or a level funded plan, really for broad compliance purposes, including the non-discrimination rules, that's going to be viewed as a self-funded plan. So when we're talking about self-funded and 105H rules, assume that those would apply to that partially self-funded plan. A few of the non-discrimination rules use the term key employee. That's a little bit different definition, kind of similar ideas. They're looking at officers with certain annual compensation. Again, looking back at the previous year, that does get adjusted slightly from one year to the next. Greater than 5% owners, but only if they're also employees. And then greater than 1% owners with annual compensation of greater than 150. I don't know why that one is not adjusted annually, but that's static at that 150,000. Before we move on to kind of putting those things together in the different tests, I do want to point out owners and non-employees. For non-discrimination rules and discrimination testing purposes, for the most part, we really exclude or ignore owners and non-employees. And the reason why is owners and non-employees are not able to participate in employer-sponsored benefits on the same tax-favored basis. Most of the time, when they're making their contributions, they have to make them after tax. They can't participate in your cafeteria plan. And if the company is paying for their coverage or a portion of their coverage, the company is required to impute that to the owners and non-employees as additional taxable compensation. So they're not getting the same tax break up front. They do sometimes, when they're filing their own personal tax return, there are special health care deductions that they can take as owners and potentially get a tax break there. So it's not that they don't get a tax break at all, but because they can't participate on the same tax favored basis as employees up front, which is what these non-discrimination rules are all about, we don't have to worry about them. We get to set them to the side and not worry about them. That also means if your company does something different for your owners or maybe your independent contractors or your board members, and you're taxing that correctly in regard to how they're participating, that's okay. That's not going to cause a problem under the non-discrimination rules because we get to ignore them. They wouldn't be included in any of your testing. Also got a question that I'll grab real quickly around annual compensation and whether that includes bonuses or just their annual salary. It is going to include everything. Everything that you're ultimately going to throw in their box one wages at the end of the year, not just their promised kind of monthly salary or annual salary. If there are commissions and bonuses and things that are going to show up in box one wages, that would count in their annual compensation typically. Also, one other question about fully insured plans, good call out. I talked about if you have fully insured plans and they're run through your cafeteria plan, they're going to be included in 125 discrimination testing. You'll notice that unless they're self-funded, I didn't call them out as being subject to testing on their own. So self-funded, then we test them again under 105H rules. We don't have to do that for fully insured plans. The ACA, when it first went into effect, added similar rules to 105H that were supposed to apply to fully insured plans. And then we would have had to apply kind of similar rules there. But those were delayed indefinitely, and we haven't seen anything further on that. So fully insured plans are not subject to any non-discrimination rules on their own. Where they get pulled in is because they're typically offered through an employer's cafeteria plan. And so then they're looked at in aggregate with all of the benefits that are offered through the cafeteria plan. So common employer scenarios, these are the types of things that we see employers wanting to differ most often. Differing waiting periods, so I've got an example of, you've got salaried employees who are eligible date of hire, hourly employees eligible first of the month following 60 days, or differing eligibility. Managers are offered a basic and a buy-up medical plan, while all the rest of the full-time employees are offered only a basic medical plan. Differing contributions. Employer wants to contribute more as employees have been working for them longer. Those are just examples. We have employers come up with all kinds of different creative ideas of how they want to differentiate for a wide variety of reasons. And so then the question is always, can we? And is this permissible? And as long as you're really doing it in kind of these specified classes categories, again, our answer is going to be maybe. It may be just fine, but what we have to jump to and look at are these non-discrimination rules. And in a lot of cases, we're probably going to recommend that you do discrimination testing, at least initially, to see if it's okay. Does it end up that you're favoring your highly compensated or your key employees too much? Now, that second example where we're differentiating for managers, much more likely to be a problem. Not automatically a problem, but certainly more likely. It's always going to depend on your kind of total employee compensation and your mix of highly compensated and non-highly compensated employees, especially as you're kind of classing things out, where those highly compensated or key employees fall. I say that because that's the answer that you're often going to get from your advisors is maybe. It might be okay. Some things are really blatantly or very likely a problem. A lot of other things, it's really going to depend on your numbers and your salaries and ultimately how you're classing things out. And the only way that you can really know is to do the testing. So these are the different tests. If you go through this and we tell you, hey, that might be fine, but we recommend that you do discrimination testing to make sure that you're not putting that tax favored status at risk for your highly compensated or key employees. These are the different tests. And you can see that when we say you have to do 125 testing, it's actually 3 different tests that get run. And you have to pass all 3 or you're not passing. You're not in compliance with 125 unless you get a passing result on all 3 tests. The only exception for those of you that only run premiums through your cafeteria plan, maybe for medical, dental, vision, and life, you don't have any account-based plans that you're running through your cafeteria plan, when you're considered a premium-only plan, you get a bit of a safe harbor and you only have to pass the eligibility test. But that's not how most of you have them set up. Most of you have a broader offering, and so then you'd have to pass all 3 tests. Under 105H, it's 2 different tests. Under 129, it's 4 different tests, and I will tell you that this is the one that we see employers have the most trouble with. Specifically, the 55% average benefit test is the one that we see employers have the most trouble with. And it's not even necessarily that they're offering it in a discriminatory way, but that looks at specifically who's participating in the plan. And if you have too many highly compensated employees maxing out that DCAP benefit and not enough participation by non-highly highly compensated participants, then you can end up failing this test, even if from an eligibility standpoint, you're in good shape. And then finally, this section 79, that's the other one, has 2 different tests. We don't see a lot of employers actually test their group life plans, or even a lot of vendors that maybe will offer that testing. So don't be surprised if you run into that. The reason why is that if employers really want to do something better in regard to life insurance for their key employees, and key employees is the definition that matters for group life insurance, they just tax that first $50,000 in benefit. It's not a significant amount of tax that would apply to those individuals. They can potentially even bump up their compensation a little bit to cover it. But instead of even worrying about testing or whether they pass or not, if there's a desire to do something more generous for the key employees, just tax those key employees on the first $50,000 in benefits rather than giving them the break on that small amount, and you're in good shape. The next question that we often get as employers are thinking about discrimination testing is kind of what does it look like? What kind of data is required? Is it something that we can do ourselves? There is some real complexity, unfortunately, to doing the testing, both in terms of correctly defining your highly compensated and key employees. That's one piece of it. Even if you get there, then doing the mathematical testing and applying it to the different IRS tables that you have to get the safe harbor percentages that apply. So most employers are not doing this themselves. They're either using a vendor to help do this, or they're using a technology software that they've purchased that will collect a bunch of data in a spreadsheet or a couple different tabs of a spreadsheet, and then will ultimately grab all that information, dissect it all the different ways that it needs to be, and then ultimately give you a result for all of those different tests that we were just looking at in the previous screen, depending on what types of benefits you offered. Regardless of what you're doing, if you're using, kind of a technology software that you've purchased and doing it in-house, or using a vendor to do it, they're all going to require you to provide a decent amount of data. If you are using an administrator, Health FSA, DCAP, HSA, that is administering some of your account-based plans, a lot of them will offer discrimination testing, and payroll vendors often will offer discrimination testing as well. I'm not saying necessarily that it's free, but maybe for an additional fee. One advantage of using those vendors is that they may have a lot of this data already, making it a little bit easier for you. But ultimately, they're going to want an employee census of all of your employees, not just the employees who are eligible, but all of your employees, because otherwise you can't correctly calculate things like highly compensated and then some of the different mathematical equations that are required. They'll need annual compensation for all of the employees, and they'll need you to designate any that you consider to be officers. They will need information about all of your benefit offerings, so be careful, especially if you're using an administrator that administers your Health FSA, DCAP, or HSA, and they're only administering a portion of your benefits. Make sure that if they're doing discrimination testing on your behalf, that they're gathering all of the information about your benefit offerings. They can't do a complete correct 125 testing for you if they're only testing on some of the benefits that you're running through your cafeteria plan, for example. They're also going to want to know who's eligible for benefits, and they're going to ask you questions about whether the different eligible employees are eligible on the same terms. Do they have the same waiting periods? Do they get the same level of employer-employee contribution? Do some get an opt-out incentive and some don't? Do they all get the same benefit plan options? They're going to ask you those types of questions so that they can help you do the testing appropriately. And then finally, they're going to want to know who actually elected to participate and what dollar amounts are being run through those plans, because that's a portion of the testing as well. When you're providing this data, in addition to making sure that you're including all of the necessary benefits, the other thing you need to be really careful about understanding is that if you are part of a controlled group or an affiliated service group with other entities, even if they have separate EINs, if you have enough common ownership, 80% or more, that you form a controlled group, you're going to be viewed as a single employer for non-discrimination rules. Same thing if you're a part of an affiliated service group due to shared management or services, you're going to be viewed as a single employer and then tested as a single employer for purposes of these rules. If you're differentiating between the different entities, that's not necessarily a problem. Again, it's, our answer is going to be that might be just fine, especially if you've got a good mix of highly and non-highly compensated employees at each of the different entities. But the way that they're ultimately going to get viewed as is like different classes or categories of employees versus completely separate plans and subject to testing individually. The next thing employers often wonder about is, as they're thinking about the data that they have to do, is when do we have to do this and how often do we have to do this? What if we haven't been doing it? Do we have to go back and test for prior years? There's no clear penalty for failure to test. What the testing does is it's a tool that if you go through and do the testing and you don't have a passing result in some areas, you have an opportunity to make corrections and bring your plan into compliance. If you don't know about it and you don't have the opportunity to make corrections and the IRS finds it later instead, that's where you have those potential tax exposures for those highly compensated and key employees. So what we say is if you haven't tested for prior years, you can't make fixes after the close of the plan year. So you just do it on a go-forward basis if you haven't been doing this in the past. What you do want to do is make sure that you hold on to the data necessary, because if ever audited by the IRS or you need to look at this or for whatever reason you do need to run testing for a prior year, as long as you have that census data, salary data, benefits information that you could put into a spreadsheet, you can always do that at a later date if you really need to. But in regard to really protecting your plan and being able to claim that you're in compliance with these rules, the conservative approach is to test at least annually. And what you want to do is test early enough in the year that you have time to make corrections before the end of the plan year. So maybe you go through open enrollment and a couple months into the plan year or even mid-plan year, then you do this testing. If ultimately you have a failure in certain areas, that would give you an opportunity before the end of the plan year to adjust the highly compensated participation in your plan and bring it into compliance before the end of the plan year. So you can do that annually. That's probably the best approach from a compliance standpoint. The reality is that some employers really don't have a lot of differentiation, or they do the testing and they pass with flying colors and they're not worried about it. And so they might be comfortable making the decision that they're not going to test again until they have some significant changes in either their staffing or their participation or the makeup of what they're offering. So that's another kind of practical approach that employers will take. Maybe you do all the testing that you need to, you're in great shape, and you say, okay, we'll revisit this in a couple of years when we make some real changes to what we're offering. I want to spend just a little bit of time talking about the testing itself so that you understand kind of the different ways that they're taking the data and why you might pass some parts of the testing and not other parts of the testing. Part of the testing, and we'll use kind of the cafeteria plans, we'll go into the most detailed, and then you'll get a sense of how the testing works for the other benefits as well. The eligibility test is truly going to look at who's eligible to participate. So it doesn't matter if they all waive or most of them enroll or what the mix might be, but it's who's eligible to participate and who's eligible to participate on the same terms. We don't have to worry about union employees or collectively bargained employees. We can exclude them. But we can't exclude very many other employees. And you'll see here there isn't an exclusion for part-time employees. I know a lot of employers don't offer benefits to part-time employees, which is generally fine, and you'll probably still pass the tests. But every once in a while, we run into employers who have a very significant population of part-time ineligible employees, and that could potentially cause a problem under the eligibility test. Also, the more that you dissect kind of the different groups of full-time eligible employees into different classes and differentiate, and you keep making those different groups smaller and smaller, and you're having to test each as kind of a subgroup, that can make it harder and harder to pass the eligibility test. The contributions and benefits test is only going to look at the employees who are actually participating. And then it's going to be how much are the non-highly compensated employees running through the plan versus the highly compensated participants running through the plan. And so they're truly looking at kind of who's benefiting and getting tax favored savings. And is that still coming out in a percentage or ratio that passes? The final piece, instead of highly compensated individuals, is looking at key employees. Again, just looking at the individuals who are actually participating in the plan. And we look at that small group of key employees. That's going to always kind of be your smallest population of employees. They shouldn't be using more than 25% of the total that's being run through the plan. That's what that test is looking at. Talking about the eligibility test just a little bit more, this is where just kind of showing you the math. This is what's going on in the background. This is why you're not just kind of doing this on the back of a napkin. This is why we can't just say, well, it's your number of employees over your, that are eligible over your total number of employees, and then it has to be 50%. Of course, it's not that simple. What we do is we look at your population, we take the number of non-highly compensated who are eligible to participate over the total number of highly compensated, and then we divide that number by the highly compensated employees who are eligible to participate over all of the highly compensated individuals. And then if you get 50% or more for your result, you're done. You're fine. Most employers are not going to meet that percentage. And so then they're going to have to, the IRS has a table of safe harbor percentages. And so then your number, depending on how big you are and how many highly versus non-highly compensated employees you have, there's a ratio or a percentage that you have to meet. And, you would still use the same equation, but then you would go to that table to see if you meet that or not. As I mentioned, sometimes we have to do it in separate testing groups because we're doing different benefits to different entities within the same controlled group. That's one example. Or we're doing different benefits for hourly versus salaried employees. And when you do that, that's a potentially okay, but now we have to break them down into subgroups and see if we still have enough eligible employees or meet the percentages required in each of those subgroups. And so I want to illustrate here, I'm not going to go through kind of all of these numbers here, but what you'll see is the denominator doesn't change. So what we're using in the denominator is still the total number of employees, but then Group A and Group B, instead of being able to do, for example, 200 out of 300 are eligible, it's 140 out of 300 are eligible in Group A, and 60 out of 300 are eligible in Group B. And so that's where I just am trying to illustrate to you that the more we break up into different classes and categories, it becomes a little bit harder to pass that eligibility test. When we look at the contributions and benefits test, one of the pieces of the test is subjective, and they look at, do all similarly situated employees get the same employer contribution, or they have the same opportunity to elect benefits? We are allowed to differentiate by tier of coverage. We're also allowed to differentiate by geographical location and argue that it's still uniformly available. But if we're differentiating outside of geographical location, that's where potentially we have to break them into the different subgroups and go back to that eligibility test and test them separately. The other part of this contributions and benefits test is mathematical, but we're looking at a little bit different thing than we're looking at for the eligibility test. We're looking at the amount, that's the dollar amounts that are actually being elected and run through the cafeteria plan. And we look at it for the highly compensated, we divide it by the highly compensated, their compensation. And then we do the same thing for the non-highly. We take the total amount elected and run through the cafeteria plan for the non-highly compensated employees. We divide it by the total kind of aggregate non-highly compensated employees' compensation. And to pass this particular test, the percentage for the amount that's being run through for the HCIs has to be less than what's being run through for the non-HCIs. Switching just slightly, one thing that I want to point out for the 105H testing, especially for the eligibility test, again, another way, in addition to the highly compensated definition being a little bit different, the other thing that's different is who can be excluded. So if you look at this list when we do the eligibility test, as long as they're not eligible to participate. So we have to be careful with that. If they're eligible to participate, we have to include them. But if they're not eligible to participate, we can include the employees with less than 3 years of service, those who are under 25 years of age, or part-time or seasonal employees. So just nothing that you need to kind of do there or understand the specifics of, but just illustrating to you why we can really see different results on the eligibility testing under 125 versus 105H. Under 129 testing, we have those 4 different tests. Similar to the previous rules that we're talking about, we're going to look at eligibility. We're going to look at what they're actually running through the plan. So those first 2 tests are kind of like the ones that I was just describing in more detail before. We're also going to do something kind of similar to that key employee test, where they're looking at owners who are also employees and that they're not getting greater than 25% of the benefit. And then finally, that 55% average benefits test, that they're saying that when you look at what's being run through the plan, you can't have the non-HCIs have to be getting at least kind of 55% or more of the pie of the kind of the total benefits that are being run through that plan. And that's the hardest one to meet. I mentioned already, what happens? So we go through and do this testing, we provide all the data, we're middle of our plan year, we find out that we passed most, but we failed a few. What do we do? And if we don't do anything, or if we find out and think, gosh, we didn't fail or we didn't pass this year, so it's likely that we didn't pass the last several years because it's a similar setup, what does that ultimately mean? Or what's the potential consequence? The reality is that probably nothing will happen unless the IRS specifically audits your plan and takes a look at this. But if that were to happen, what the IRS could do is, like I described before, they'd reverse just for the highly compensated and key employees the taxation. So it would be included in their income taxes retroactively, adjusting W-2s, the hassle of that. The employer would retroactively owe additional payroll taxes tied to that. And then the IRS would be able to assess late penalties on both because those penalties should have really been paid in prior years. So that is the potential risk, is that then they could take and they could tax all of the benefits for the highly compensated or key employees that were run through that discriminatory plan. So what do we do? If we figure this out mid-year and there's time to make corrections, a lot of the vendors are going to give you a report that says, you passed this particular test, you passed this particular test, you failed this piece, and they'll go through and they'll let you know test by test. And then the other thing that they'll often do is they'll say, these are kind of the amounts that have to be adjusted for you to bring your plan into compliance. So for those ratios, it's all about numbers. And so they'll say if you can reduce, for example, the amount that your highly compensated employees are running through your DCAP plan by 20,000, then it will bring your plan into compliance. And so then you have to go through and look at that particular plan and see, how many of your highly compensated employees do you have to adjust, either, excluding them from the plan completely or adjusting the amount that they're running through the plan to bring your plan into compliance. The options for corrections are a little bit different depending on what types of plans we're talking about. And so I've got kind of 3 of the most common categories here. For plan premiums, if you are not passing, for example, under 105H, what are your options? How do you adjust what amounts have been handled on a tax favored basis or will be through the end of your plan year? Couple things that you can do, and you might have to do a combination of these things to ultimately hit the right numbers. One is you could handle any remaining employee contributions for the rest of the year after tax. Don't let them make them pre-tax or only allow them to make a little bit more on a pre-tax basis. You can impute taxable income for employer contributions that have been made. So no money is being exchanged. That's just been going toward the benefits, but instead of excluding it from their box one income, you include those amounts in their box one income. Or you can include previously made contributions. Maybe you already, it won't be enough just to switch to after tax for the rest of the year. You have to do more. And so you reverse some of those amounts that they've already paid that you didn't include in their box one income, you do include in their box one income. For an FSA or an HSA, especially because a lot of that's going to be employee contributions toward those accounts, your options are that you can limit any further tax-favored contributions and tell them that they have to be cut off to bring the plan into compliance. You can return already contributed amounts that haven't been reimbursed yet as taxable income, or you can include already reimbursed amounts in their taxable income, so that ultimately you're changing the amount that they ran through those plans on a tax-favored basis. Kind of similarly for an HRA, a little bit different because it's only employer contributions, not employee contributions, but you can include any previously reimbursed amounts in their taxable income to the extent that that's needed, or you can cut them off and say you're only able to participate up to $3,000 instead of $5,000, and so once you hit that $3,000, we can't provide you any further reimbursement on a tax-favored basis. So those are the different ways that you would ultimately correct things depending on what types of plans you're working with. And if you can adjust, again, it's just going to be your highly compensated or key employees. You don't need to make adjustments for any of your non-highly compensated employees, but you're adjusting how much your highly compensated or key employees are running through your plan on a tax-favored basis and taking some of that and saying, I know you made this election, we're going to have to go back and you're only going to be able to participate up to X on a tax-favored basis, and the rest is going to be included in your taxable income. Final thing I want to mention is sometimes we run into employers that they're in the middle of fixes for their current plan year and they kind of get done with that, or they find out after the fact that they didn't pass, and they year after year have issues with passing discrimination testing. And so the employer says, gosh, instead of going through and every year getting to the middle of our plan year doing the testing, we always fail, we always have to make adjustments, it's a hassle, we have to communicate it to the highly compensated individuals, we're reversing things for payroll. You might decide that you want to be more proactive to address that up front and kind of limit that exposure and hopefully kind of start things off from the get-go when you're going through open enrollment in a way that you're more likely to pass. And so these are some of the options that you can do rather than just waiting and testing and fixing it mid-year, that you can be proactive where you know that you typically have issues. So one thing that you can do, but this is by far the most extreme, is that you can exclude highly compensated or key employees from participating at all. Or maybe you let them participate, but they can't do it on a tax-favored basis. They have to make their contributions after tax, and any employer contributions are included in their taxable income. Not ideal, and pretty extreme to go that far and just say they can't participate at all, but that is one option. I will say we see that most often when employers really struggle to pass in regard to their dependent care FSA, that they'll just say, going forward, we just can't allow our highly comps to participate because we can't ever get a passing result that way. A medium approach would be to, instead of excluding them completely, is say you can participate, but let's use dependent care for an example again. Everybody else is going to be able to elect up to $7,500, but our highly compensated employees, you can only put $5,000. You can elect up to $5,000. But by capping that and having them run a lower amount through the plan from the get-go, that ends up in a place that you don't have to make adjustments mid-year. So that's another way that you can do it. A final approach that you could consider is sometimes the issues are not about eligibility up front. You've got enough people eligible, but you're not getting enough of your non-highly compensated employees to participate. So you can do different things to encourage them to participate, or if you really need to, expand your eligibility rules to allow more non-highly compensated employees to elect and be eligible for your plans. The more non-highly compensated employees who are eligible and actually participating in your plans, it's going to make it easier for those highly compensated employees to really take advantage to the full extent and still leave you with a passing result. All right. Lots there. That was what I wanted to cover today. I tried to answer a few questions as I went through, but I'll kind of leave you with, that there really is. I hope you understand that there is some complexity to these rules and kind of understanding which rules apply, which definitions apply. That this is why we can't give you an easy answer. Your broker won't be able to give you an easy answer when you say, well, we want to do this. We want to do this for location A, and we want to do this for location B. And can you just tell us if that will pass the non-discrimination rules? And they're often going to have to recommend that you run this testing and ultimately see the results to know if that's going to be okay from a tax favored standpoint. But reach out to your brokers on those things. They can help you navigate which rules apply, which vendors might be a good fit for you, and then help you kind of navigate if you do need to make some adjustments from one year to the next or even mid-year, how you do that. And then of course with your payroll vendor as well. But I hope that gives you kind of a sense of these rules and how they work and why you're getting some of the direction that you do when you ask those questions. But with that, I will turn it back over to you, Jenny.
Great. Thank you, Reagan. You covered a lot today. Really appreciate your time. As we close out here for our audience, if you're with us at the top of the hour, we asked you a couple of questions on men's mental health, as June is Men's Mental Health Awareness Month. We have two follow-up questions for you. So if you take a moment and provide your responses to these two questions as we close out here with a couple of items. As Reagan mentioned, your broker is a great resource to dig into this topic further. If you have further questions or want to take some action based on what you learned today, please do reach out to that broker who invited you to the webinar today. And again, we want to extend our thank you and appreciation to those brokers who are partners of Assurex Global for making this webinar series possible. And as a reminder, we did record today's webinar. So if you are looking for a link to the recording, if you would like to revisit this webinar or share it with a colleague, you can reach out to that benefits broker who invited you here today. They will be able to provide you with a link to the recording, as well as a copy of the slide deck if you did not get a chance to grab that earlier. And I will give this poll just a second here, these two polls just a second here to capture those last couple of responses, and I'll share those out so you can see how your peers are approaching these two questions, and then we can let you get on with your afternoon here. So give me just a moment here. Okay, so we think that fear of stigma or judgment is maybe that top thing that's preventing men from seeking that mental health support. And when we're looking at what you might be investing in over the next couple of years relating to men's mental health, got a little bit of a variety here. Many of you are not sure, some of you don't have any plans, but preventive health and mental health and resilience programs are those top two for those of you looking to take action. So again, we always appreciate your responses to our polling questions. Thank you again for joining our webinar today. That does conclude our time together. Have a wonderful afternoon.